Before we begin this conference, I would formally request the esteemed dignitaries to kindly grace the dais. Honorable Mr. Justice Amreshwar Pratap Shahi, President, National Consumer Dispute Redressal Commission, New Delhi. Honorable Dr. Justice Vidyut Ranjan Sarangi, Member, National Human Rights Commission, New Delhi. Honorable Mr. Justice Anand Sen, Judge, High Court of Jharkhand. Honorable Mr. Justice Rajiv Ranjan Prasad, Judge, High Court of Patna. Learned Advocate General Bihar, Shri P.K. Shahi Sir. Director General BIPAD, Shri K.K. Pathak Sir. Additional Chief Secretary, GAD, Government of Bihar, Dr. B. Rajendra Sir. I request the dignitaries to take the seats.
Moving towards the inaugural session, we would humbly request the esteemed dignitaries on the dais to kindly come forward for lighting the lamp. Thank you to the honorable dignitaries. Now I humbly request you all to kindly rise at your respective place for national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We welcome you to the one-day national conference on the topic, the issues and challenges faced by the Commission and Tribunals and the solutions thereof, which is being organized jointly by the Board of Revenue Bihar and Bihar Institute of Public Administration and Rural Development. I, Amit Kumar, Law Faculty BIPAD, along with my co-host Bhavya Mishra, Assistant Prosecution Officer, Bihar, feel privileged and honored to address this gathering.
State commissions and tribunals are the cornerstone of our legal system. They serve as vital instrument for redressal enabling the citizens to seek remedies and ensuring that the principle of justice are accessible to all. But these institutions often face a range of challenges like resource constraint, legal ambiguities, and growing caseloads that hinders their ability to function effectively. Today, we have gathered here to discuss the vital role these institutions plays in ensuring justice, fairness, and transparency within our legal system.
Today, as we convene with our honorable judges, legal experts, policy makers, and practitioners from across the country, we have a unique opportunity to not only highlight these concerns, but to explore actionable solutions that will pave the way for reform. Now, we would like to invite our Director General BIPAD, Shri K.K. Pathak Sir, for his welcome address. Sir.
Ladies and gentlemen, it is with profound gratitude and reverence I welcome the Chief Guest, Honorable Mr. Justice Amreshwar Pratap Sahi, President NCDRC New Delhi, Honorable Justice Dr. Vidyut Ranjan Sarangi, Member NHRC, New Delhi, Honorable Mr. Justice Anand Sen, Judge High Court, Jharkhand, Honorable Mr. Justice Rajiv Ranjan Prasad, Judge Patna High Court, Honorable Mr. Justice Rajesh Bhardwaj, Judge High Court of Punjab and Haryana, Chandigarh, Honorable Mr. Justice Purnendu Singh, Judge Patna High Court, Shri P.K. Shahi, Learned Advocate General, Bihar, Honorable Mr. Justice Sanjay Kumar, President, SCDRC, Bihar, Honorable Mr. Justice Sanjay Priya, Chairman, Bihar Land Tribunal, Honorable Mr. Justice Shri Rajendra Kumar Mishra, Chairman, Riyadh, Honorable Mr. Justice Lalit Batra, Chairperson, Haryana Human Rights Commission, Honorable Mr. Justice Gautam Chauradia, President, Chhattisgarh State Consumer Dispute Redressal Commission, Honorable Mrs. Justice Dr. Sangeeta Digra Saigal, President, Delhi State Consumer Commission, other chairmen and members of esteemed commissions, RERA RIAT, SHRC, SCDRC, SIC, SC, PCR, SERC, officers of Board of Revenue, and additional collectors and presidents of the LAR of the state of Bihar, who have come from 16 different states and union territories. A very warm welcome and heartfelt greetings for this one-day national conference on the issues and challenges faced by the state commissions and tribunals. It is a matter of great honor for BIPAD to host such an esteemed gathering in Bodhgaya, a place that has, for centuries, been a beacon of wisdom and peace. We are all aware that justice is not merely a legal principle. It is the foundation of a just and equitable society. State commissions and tribunals that were created with the noble intent of providing swift and specialized justice, yet they face numerous challenges. Procedural complexities, jurisdictional limitations, administrative bottlenecks, and infrastructure constraints, which often hinder their effectiveness. Justice is meaningful only when delivered on time, else judgments become history, not rights. It is our collective responsibility to ensure that these institutions remain efficient, accessible, and robust, upholding the faith that people place in them. This conference, therefore, serves as a platform for discussions, innovations, and policy refinement to overcome those obstacles that stand in the way of timely and fair justice. Today's sessions, ladies and gentlemen, would be numerous, and we plan to finish by the end of the day, by the evening. There will be two plenary sessions in this hall. One is the inaugural session that we are going through right now. The last one would be the valedictory. After the inaugural, we will break out In technical sessions, I have a pleasure to announce that there are 3 technical sessions which we have planned, and due to the active participation of esteemed delegates, we hope that these technical sessions will be very successful. One technical session would be in the committee hall 1, that will be on consumer disputes, and the other technical session would be on the human rights and child rights, which is on the committee hall 2. In the plenary hall, after the coffee break, we reassemble the remaining delegates for the technical session on revenue disputes, transparency in governance, and citizen empowerment. I hope these 3 sessions would be very enriching, enlightening. We will all go back little more knowledgeable, little less confused, and little better motivated to see how we plan to work henceforth. The technical sessions may be very long. We have kept the time for about 1 hour 45 minutes, but I would suggest, sir, in case what we see is there are a lot of PowerPoint presentations. So in the committee hall 1 and 2 across this hall, if the sessions continue, I would request the honorable chairpersons and the delegates to continue till as long as they are able to finish. Then we can those sessions can break out for lunch at a little later period, but we have kept the time rather flexible for the technical sessions because we were very heartened to see that there are a lot of presentations here. So time would not be a constraint, sir. Then after the lunch, we can reassemble here for our plenary session on problems and challenges faced by the state commissions. Those technical sessions who are still continuing, they may continue, sir, and we can reassemble at least for the valedictory at 4 o'clock. So that is the flexibility for the technical sessions, depending upon the kind of discussions, kind of brainstorming we see in the technical sessions. My request to the chairpersons and the delegates would be that, so please feel free, do not feel constrained of the time, sir. We have kept enough leeway and enough flexibility in the schedule. It may be noted that these discussions would not just be academic exercises, but an opportunity to drive meaningful change in how justice is delivered and perceived in our country. If the law remains bound in shackles of rigidity, then the pace of justice too shall slow down. Today's deliberations must inspire not just word but action, not just discussions but resolutions, and not just awareness but transformation. I truly hope, sir, that the insights and resolutions emerging from today's discussions will resonate beyond this hall, influencing legal policies, administrative frameworks, and public trust in our judicial mechanisms. Let this be the beginning of a wider movement, a commitment to strengthen justice delivery systems for generations to come. With these thoughts, I extend my warmest welcome once again to all of you. Thank you.
Thank you, sir. Moving forward, we would like to invite Learned Advocate General Bihar, Shri P.K. Sahi, sir, to address the gathering.
A very good morning to all distinguished delegates present here. Honorable Justice A.P. Shahi, former Chief Justice Patna and Madras High Court and presently President NCDRC. Honorable Justice B.R. Sarangi, former Chief Justice Jharkhand High Court, presently Member National Human Rights Commission. Honorable Justice Rajiv Ranjan Prasad, Honorable Justice Anand Sen, Judge of Honorable Jharkhand High Court, Honorable Justice Purnendu Singh, Honorable Justice Pandey, Honorable Chairman and members of different state commission and tribunals, members present here, friends from media. In continuation of the last session on of NJ, Mr. Pathak, Member Board of Revenue, and Director General BIPAD has organized this one-day conference to deliberate on issues and challenges being faced by state commissions and tribunals. He discussed with me that he proposes to hold a conference to go in detail about various issues and challenges which the commission and tribunals across the state, across the country face. And he also discussed about topics, the delegates who are likely to participate, since it would be a pan-India conference, and I am glad that he has made this successful. As it is, many of you present here might have seen BIPAD, Bihar Public Administration and Rural Development Institute, which apart from discussing various nuances, not only discussing, implementing various nuances of administration, is a pivotal institute of training established in the state of Bihar, which caters for training of various officials from the state of Bihar. And now BIPAD is partnering with other states also in providing basic inputs, basic training. So it is in the aegis of BIPAD and Board of Revenue that this conference has been organized. Needless to say that commissions and tribunals were conceptualized as an alternate mode of providing adjudication of disputes, legal disputes of various natures. As it is, the judiciary is overburdened, be it the High Court, be it the district courts, or even Supreme Court. Cases take decades in getting resolved. Therefore, it was thought that commissions and tribunals will provide an alternative mechanism to lessen the burden of existing system of adjudication and provide speedy relief to the citizens of the country. However, in course of time, nobody would dispute that the purpose and object didn't succeed in the manner it was thought of. Commissions and tribunals are facing umpteen number of issues, resultantly challenges. Tribunals are without chairman, without member for years together, lack of infrastructure, delay in making appointments. These are some of the issues which plague the functioning of the tribunals. Resultantly, it has not been able to deliver in the manner people might have thought of. In the state of Bihar itself, various tribunals, for example, Bihar Arbitration Dispute Resolution Tribunal is without a chairman, without a member. In 2008, sometimes in 2008, we thought of having a tribunal for resolution of contractual disputes, and therefore Bihar Arbitration Tribunal was established. Whenever it functions properly, it provides relief. But on account of appointments not being made, it suffers. Similarly, there are other tribunals, other commissions facing similar challenges. Mr. Justice Mishra is sitting here. She is chairman of Real Estate Regulatory Appellate Authority. I think he faces same kind of challenge, namely that staff has not been appointed. These kind of difficulties and shortcomings are facing almost all the commissions and tribunals, not only at the level of a state, even at national level. In 2017, GST came to force. We are yet to have the tribunal of GST. Supreme Court is constantly faced with resolving the issues of appointment. There is always variance in opinion. Sometimes the government says the tenure should be 4 years, 3 years. These kind of issues keep on engaging not only the government but also the Supreme Court at the highest level. These are some of the issues, and I am hopeful that in today's technical session and later on in the plenary session, the chairman and members of different commissions and tribunals, after deliberation, would flag some of the issues which I am sure that Mr. Pathak would take up at appropriate level to apprise about the result of the discussions, so that corrective measures can be taken and taken promptly. There are other speakers also. I would not consume much of the time, but I only hope and trust that this conference yields result which the issues and challenges the commissions and tribunals are facing. Thank you very much.
Thank you, sir. Now we would like to humbly invite Honorable Mr. Justice Rajiv Ranjan Prasad, Judge, High Court of Patna, to say a few words to address the gathering. Sir.
The esteemed dignitaries on the dais, Honorable Mr. Justice Amreshwar Prasad Sahi, the former Chief Justice of Patna and Madras High Court, presently the President of National Consumer Disputes Redressal Commission, New Delhi. Honorable Mr. Justice Vidyut Ranjan Sarangi, the former Chief Justice of Jharkhand High Court, presently member of National Human Rights Commission. Honorable Justice Anand Sen, Judge Jharkhand High Court. Mr. P.K. Sahi, Learned Advocate General, Bihar. Mr. B. Rajendra, Principal Secretary, General Administration Department. And Mr. K.K. Pathak, IAS Director General of BIPAD. Of the dais, my esteemed brothers, Justice Purnendu Singh, Justice Dr. Ansuman, Justice R.K. Mishra, Justice Sanjay Kumar, Brother Judge Justice Sanjeev Kumar Panigrahi from Odisha High Court, my brother Justice Sanjay Kumar from the State Consumer Dispute Redressal Commission, Bihar, heading the commission, honorable judges heading the different state commissions and tribunals from different states, speakers, delegates and participants. It is said that knowledge shared is knowledge acquired. It's a famous saying. Bob Buckman said, do not be afraid to share what you know, because you know better than anyone else. Chris Collison and J. Parcel said, you cannot manage knowledge, nobody can. What you can do is to manage the environment in which knowledge can be created, discovered, captured, shared, distilled, validated, transferred, adopted, adapted, and applied. Today, all we have gathered here to share, discover, and capture the knowledge. I must acknowledge the great efforts by BIPARD under guidance of its able and competent Director General, Sri K.K. Pathak, in making of an environment at this place where we can indulge in discovery, sharing, and transferring of knowledge with each other. This one-day national conference on the issues and challenges faced by the State Commission and Tribunals, followed by 3 technical sessions, is going to be extremely exciting and remarkable. With the presence of my former Chief Justice, Sri A.P. Shahi, whose exceptional intelligence and profound knowledge of law has always been recognized by the judicial fraternity, and other esteemed speakers, we all are likely to be immensely benefited by the discourse. And at the end of the day, we will be going with an improved and greater knowledge. In this conference, we are going to have discussions on various aspects of law. So far as the issues and challenges which are being faced by the tribunals are concerned, no doubt I share the concern raised by the learned Advocate General here, that the object behind establishing the tribunal was to provide an effective and speedier forum for dispensation of justice. The reasons behind their establishments were cheaper, cost-effective, accessible, free from technicalities, expeditious, and to proceed more rapidly and efficiently, because it was thought that the tribunals would be manned by experts, while the courts are too remote, too legalistic, and too expensive. The concept of tribunalization was developed to overcome the crisis of delay and backlogs in the administration of justice. However, the data officially available in respect of working of some of the tribunals do not depict a satisfactory picture. Some of the reasons have been explained by the learned Advocate General just now. There are huge pendencies of cases in Central Administrative Tribunal, Railway Claims Tribunal, Dates Recovery Tribunal, Custom Excise and Service Tax Appeal Tribunal, and Income Tax Appellate Tribunal. I'll tell you my own experience when I started practice in the year 1991, when I was going to a State Consumer Dispute Judicial Commission or the District Consumer Forum. If a matter was to be adjourned, I was getting a date for only after a week. Believe me, only after a week. But I myself found only after a few years, by the end of the year 2000, that I was getting a date after 2 months. And then it became 3 months, 4 months, 5 months. The situation is no better at any place, whether it is this state or another state, or for that region even the National Consumer Dispute Judicial Commission, where we had occasion to appear as a lawyer, and even today we find that though the Honorable President of the Commission is taking all out efforts, sitting right from morning to late evening, disposing of the cases, the fact remains that in some of the cases, the Commission is unable to give a date within 1 or 2 months. The matters are adjourned for 4 months, 5 months, 6 months. So this is an example how this concept of tribunal has not fulfilled our ambitions to offload the cases from the courts and to virtually act as a substitute for the courts. One of the issues which we have already discussed through judicial pronouncements, that whether this establishment of the tribunals are by way of a substitute to the court. When Swan Singh Committee made recommendations leading to insertion of Chapter 14A in the Constitution of India, titled the word tribunals, and Article 323A and 323B were inserted in the Constitution of India to make way for establishing the administrative tribunals at the level of the central government or the state government or any other tribunals by virtue of Article 323, capital B. The object behind that was to provide a forum meant by experts where people can get expedient justice and at the same time they can get benefit of the experts with technical opinions. But over the period, only after a few years, the Honorable Supreme Court had to deal with a matter in L. Chandra Kumar, where their lordships had to consider whether this tribunal may be taken as a substitute of the court. The answer was very obvious, no. The tribunals are not court and they cannot substitute. It is for that reason that clause D of subclause D of clause 2 under Article 323A and clause D, subclause D of clause 3 of Article 323B were struck down by the Honorable Supreme Court. And it was held that no, the judgments of the tribunal would be amenable to the writ jurisdiction of the High Court, because you cannot take away the basic features of the Constitution. And what had been done by the legislatures by providing those sub-clauses was that they had taken away the jurisdiction of the High Court and the Supreme Court except the jurisdiction of the Honorable Supreme Court under Article 136 of the Constitution. So that was held bad in law and was struck down. Now, we have discussed many challenges in past also. I need not detain myself saying that one of the issues which I feel is very important, and in fact the Learned Advocate General had given me that topic when he referred the act, namely the Bihar Works Contract Arbitration Disputes Tribunal Act of 2008. The issue which I would like to flag here is with regard to the independence of the tribunal. I would invite Learned Advocate General to please see Section 4 of the 2008 Act. What it provides for? The government can remove the chairman or the member of the arbitral tribunal on the grounds inter alia of incompetency, and by saying that, look here, you have delivered a judgment contrary to the law. Now, what kind of provision is this? What you are doing? You are establishing a tribunal to decide a works contract dispute in which you are a party. The state is a party to that works contract dispute. You are appointing chairman and members. And that appointment, of course, includes power to terminate also. It's a well-settled law. And then what you are doing? You are providing for a provision that one fine morning, I may take a call in the secretariat to remove you because you are incompetent. Now, how will you judge incompetence? What will be the guiding factor for that? When you say you have decided a judgment contrary to law, what will happen if that law is reversed by the Honorable Supreme Court after 2 years? So, the issue which I am flagging here for this august House to consider and render your opinion as to whether the tribunals are independent and they can act independently. You are providing a provision for reappointment of the chairman and member. Why is this? If you are providing a provision for reappointment of the chairman and member, why will he not go on passing an order in your favor? So I am not saying it's a perception that may happen. Why he will not go on passing an order in your favor, not giving an award against the government in his quest for getting another term as chairman or member of the tribunal? So, I feel privileged here that I have been given an opportunity to discuss this issue in presence of the learned Advocate General. And I am sure that the issue which is being flagged today will definitely be taken care of by him in his own capacity. The another issue which had been cited times and again, and I think even with the enactment of this Tribunal Reformation Act of 2021, those problems still exist. Because what the Tribunal Reformation Act envisaged, the Act wanted to lay down a procedure for appointment, selection of the chairman and members of the commission, a search committee. Who will comprise the search committee? The Honorable Chief Justice of the High Court and the other members at the level of the Secretary to the government. Now, why the search committee is not able to find out a suitable person for years together? This is another issue which is required to be flagged. Whether the legislation has failed to work despite a lapse of 4 years since 2021, we'll have to think over it. Because by mere enactment and reformation statute, we cannot think that everything will come to its fore. It is ultimately we who are responsible to execute that. We have to take this responsibility on our shoulder. We have to be sensitive that what we are doing. We are sitting over the matter for last 2 years, no chairman, no member. So every stakeholder, whosoever he is, has to be very sensitive on this issue. Because it relates to doing justice to those who have come to you. And justice does not mean that you do it at your own will and volition at any point of time. No, that would not be a justice. These are the issues which I would like to flag. I would not be fortunate to be present in the technical session which my former Chief Justice would be presiding over. Initially, I thought that I'll be there. I could not see that I'll have to be in a different hall, participating on a different subject. But the topic which my former Chief Justice is going to deal was my topic, law of insurance. I was a student of law of insurance and I dealt with thousands of cases in the insurance matters. Life insurance, general insurance, everything. So I was happy going again reading that principle of Uberima fight, utmost good faith, I remembered the judgment, three judges, judgment, celebrated judgment of Mithulal Nayak versus this 1962 Supreme Court, page 814. And then going through your lordship subject, I found that again medical negligence is one of the topics which is going to be discussed there. So again, Matthew Jacobs case, because when we were practicing, a lot of doctors were falling prey to this Consumer Protection Act and at the same time going behind the bars facing criminal prosecutions. So we had occasion to defend many doctors. Now that law has been crystallized to a great extent. I believe the recent judgments, the D'Souza judgment and all, where their lordship said that unless the parameters laid down in the Jacob Matthews case are not present, you cannot arrest a doctor. Now I find that even BNS has been amended and a subsection 2 perhaps has been added to section 304 of the BNS, where a doctor may be prosecuted for gross negligence only, culpable negligence only, and perhaps the sentence would be for a maximum period of 2 years. So these are the developments in law. I'm sorry I would be missing that session, but nonetheless I would learn something from you outside this. Yes, the another topic which we are going to discuss today is with regard to the understanding of the national and international child protection laws. And these are very good topics which I think the Director General Bipard has chosen. It's a very wide canvas on which we will be discussing Juvenile Justice Act, POXO Act and child labor laws. Yesterday when I was preparing for this, I went through one of my own judgments in which I had received a WhatsApp message from my former Chief Justice when he was Director of National Judicial Academy. He said, "ये आपका कौन सा judgment है?" The paper news was that बच्चा पैदा करने के लिए 15 दिन का पैरोल मिला. Sir, you will remember I got your message and then I sent you that judgment which I had occasion to deliver. That was a case in which a 24-year-old woman had come to the High Court. By filing a criminal writ application, her prayer was that please allow parole to my husband for some family reasons. What was the family reason? She explained. She said, look here, when I was 23 years old, I was married to this man. But only 4 months after my marriage, he became an accused in a murder case. He went behind the bars and then he was convicted. He has been awarded life imprisonment. For last 8 years, he is in jail. And I am developing infertility. I am not getting treatment. There is no one in my family to look after me. And if you do not leave my husband for a few days, I would not be able to become mother in my life. I tell you, the lawyer was very weak. Lawyer had not drafted the writ application very well. I was not very happy with the drafting. But then it came in my mind as a student of law that here is a writ application. It may not have been very well drafted, but I am a judge. I understand what she is saying. So why can't I do some research on my own and develop the law and then try to find out whether a relief may be granted to this lady? The stand of the state was that no, we do not grant parole under the Bihar Parole Rules 1972 for this reason. she wants to become a mother. No, this is not a region provided under the word family regions under the Bihar parole rules. So we will not grant him parole. This was the stand of the state. Then it was my duty to see within the boundary of law how to do it. So I decided that case, and I said that even if a person is imprisoned, he has been convicted, he does not lost on his entire fundamental rights. The fundamental rights still remain. He loses only that much of freedom which incidentally happens to him because of his confinement in jail. And therefore, taking a cue from the international covenants relating to right of the prisoners, I was of the view that the definition of family region as provided under the Bihar parole rules, which start with the word means and includes, is required to be done in such a manner that it would include the region which this lady is looking for. And I directed the state government to provide her husband a parole for 15 days. And then I suggested various jail reforms in my order. And then I forgot what happened to that order. The state had gone in appeal before the Honorable Supreme Court. And after about a year, the Supreme Court refused to stay the judgment. Then that was implemented. And there was the newspaper report, which my Lord Justice Shahi had gone through, and then he questioned my judgment, what kind of judgment is this? So I had to send that judgment. So this story I shared with all of you, because what impressed me, that observation of the Honorable Supreme Court in Charles Sovraj case. It's a beautifully worded, and I am tempted to quote that. That only 4 lines I will read. I know I am taking some time, but Mr. Pathak said earlier that don't worry about time, so I am taking this liberty. In Charles Sovraj case, the Honorable Supreme Court said, I quote that relevant part only, whenever fundamental rights are flouted or legislative protection ignored to any prisoner's prejudice, the writ will run, breaking through stone walls and iron bars to right and wrong and restore the rule of law. Then the parrot cry of discipline will not deter, of security will not scare, of discretion will not dissuade the judicial process. So this is something which I believe should be the role of the court while protecting human rights. Now, many other things may be discussed, but I want to pause here. I had been a student of my Chief Justice. He was always taking me in the full bench and was always telling me to write judgments. So I got in habit of writing more and more pages just to please him. So this time I have prepared many things, but the time is not permitting me. I will leave it for the next time. Thank you. And of course, Dr. Ansuman, my brother, will be discussing that consolidation matter. So I will only point out to you, I think you must have gone through that our special bench 5 judges judgment in case of Prabhavati Kumari, again chaired by the Honorable Dida and Honorable Chief Justice. And there we all had written, because the Chief Justice mandate was that all of you should write the judgment. So Brother Justice Sanjay Priya, he is here, and me, we were from the bottom. I was the last one, and just above me was Justice Sanjay Priya. We had also to write that judgment, though we were finding ourselves in a very difficult position, but that was the mandate of the Chief Justice, and so we wrote that. So with this, I end here. Thank you. Jai Hind.
Thank you, sir. Now, we would take a humble opportunity to invite Honorable Justice, Mr. Justice Ananda Sen, Judge, Jharkhand High Court, to address this august gathering.
Good morning to you. Honorable Mr. Justice A.P. Sahi, President, NCDRC. Honorable Justice V.R. Sarangi, Honorable Member of NHRC, whom I address as my Chief Justice. Brother Rajiv Ranjan Prasad, Learned P.K. Sahi, Advocate General, Bihar. Mr. K.K. Pathak, Principal Secretary, Dr. B. Rajendra, dignitaries of the dais, my brothers and sisters, members of state commissions, tribunals, and other esteemed delegates. It is indeed an honor to be present here at BIPAD for the one-day national conference focusing on issues and challenges faced by state commissions and tribunals. I commend the organizers for choosing such a pertinent theme, one that has direct implication on access to justice and effective governance. This conference is not just an academic exercise. It is a platform to address some of the most pressing concerns affecting our justice delivery system. State commissions and tribunals play a vital role in our justice delivery system. As a quasi-judicial bodies, they are entrusted with specialized functions, often stepping in to ease the burden of regular courts. Whether it is resolving consumer disputes, labor issues, environmental concerns, or ensuring social justice, these institutions serve as crucial pillars in upholding constitutional rights. In today's conference, there will be multiple topics of discussion which are divided in 3 technical sessions. One on consumer rights, another on human rights and child rights, and another land reforms and right to information. There are key challenges which are faced by state commissions and tribunals. While their significance are undisputed, we must also recognize the numerous challenges which they face. Shortage of personnel. Many tribunals and commissions face acute shortage of staffs, including vacancies in key positions such as presiding officers and technical members. This hampers their ability to deliver timely justice. Infrastructural deficiencies. Limited resources, lack of dedicated courtrooms, and inadequate technological infrastructure further delay the proceedings. The absence of digitized system often result in inefficiencies these days. Pendency and delays is one of the greatest concern. Despite being designed to expedite dispute resolution, commissions often mirror the delays witnessed in traditional courts. This frustrates the very purpose of their creation. Judicial confusion. Overlapping powers between commissions, tribunals, and regular courts sometimes result in jurisdictional ambiguity, creating procedural complexities. Limited aware and accessibilities. Citizens are often unaware of their role and jurisdiction of this institution, limiting their liability to effective approach commissions for redressal of their grievance. I also emphasize the importance of viewing these challenges not as an obstacle, but as opportunities. Opportunities to strengthen our judicial and quasi-judicial bodies, improve access to justice, and enhance public trust in our legal system. Addressing these challenges requires a multi-pronged approach, strengthening human resource by expediting appointments to the vacant positions and ensuring adequate training for members can greatly improve efficiency. Investment in technology-driven solutions such as e-filing system, virtual hearings, and digital case management can accelerate dispute resolution. Legislative reforms may be necessary to ensure clarity on scope and authority of various commission and tribunals. Brother Rajiv had hinted the legislative reforms and enactments of law. Now, enactment of law in many of the cases is not a solution, it is becoming a problem. Public awareness campaign is absolutely necessary. Greater efforts must be made to inform citizens about their rights and remedial reforms available to them, which the lowest strata of our civilization, of our citizens do not have. The encouragement of alternative dispute resolution. Initiating mediation and conciliation process within tribunal frameworks can provide faster and more amicable resolution. State commissions and tribunals were envisioned to be dynamic institutions that provide swift, specialized justice. While they have achieved much, the challenges they face demand our collective attention. As stakeholders, we, the members of the judiciary, government, and civil society, must work towards strengthening these institutions to ensure they fulfill their intended purpose. As we engage in the technical session, I encourage all of you to focus on practical solutions. Those are adaptable, scalable, and grounded in our constitutional values. The success of commissions and tribunal lies in ensuring justice that is not only delivered but also accessible, affordable, and which are timely. I am confident that today's conference will generate valuable insights and constructive solutions to address these concerns. I urge all the participants to engage actively, exchange their ideas, their problems, their innovations, what they have done in their personal capacity to overcome these problems so that others can also accept them. On this note, I once again express my gratitude to the organizers for inviting me, and I wish this conference a great success. Thank you.
Thank you, sir. Now, we would like to invite Honorable Dr. Justice Vidyut Ranjan Sarangi, Member, National Human Rights Commission, New Delhi, to share his thoughts to address the gathering. Sir.
Jai Jagannath, my esteemed Honorable Mr. Justice Amareshwar Pratap Sahi, the President of National Consumer Dispute Judicial Commission, New Delhi, my esteemed brother, Honorable Justice Anand, my colleague and my younger brother in Jharkhand High Court, Honorable Mr. Justice Rajiv Ranjan Prasad, the Judge of High Court of Judicature, Patna, Mr. P.K. Shahi, the Land Advocate of Bihar, Mr. K.K. Pathak, the Director General of BIPAT, and Dr. B. Rajendra, the Additional Chief Secretary to Government of Bihar, General Administration Department. My esteemed brother and sister judges of the dais, and specifically my younger brother, Honorable Dr. Justice Sanjeev Kumar Panigrahi, who was once upon a time my colleague and younger brother in Odisha High Court, and all these members of different commissions, tribunals who are present of the dais. Really, it is a great day for me at least that Board of Revenue, Bihar and Bihar Institute of Public Administration Rural Development Department have decided to have this conference with the issues of and challenges faced by the state commissions and tribunals. This is a very burning topic. Why I am saying so? The reason being,
that when I was a judge and also Chief Justice of a High Court, this part of the things which we are now discussing was not known to us because of the reasons that things have gone in such a way, what my brother Justice Rajiv Ranjan was saying, that initially only 1 week time was granted in a consumer dispute matters, but now my brother Honorable Justice Sahi could not find out time at least for 4 months to grant time. So granting of time is one of the factors for adjudication of a case. But what is the reason behind it? Reason behind is that there is a lack of coordination, lack of communication, lack of funds, lack of staffs, lack of infrastructures, lack of the motivation to do the work. But is it a way to solve the problem? I am asking this question to myself. Reason is, for the purpose for which these tribunals and commissions have been constituted, are you able to discharge our responsibility assigned to us? This is a very big question mark. Reason being, I am asking that if the tribunals and commissions have been constituted for the purpose of the benefit of the public who are in need of getting the justice at their doorstep, are we satisfying the requirement of constitutional mandate? We have been created by a law under the Constitution. If we have been created under law by the Constitution, have I been given that autonomy to discharge our responsibility? These are the questions which are to be discussed in different technical sessions, and we have to answer it. I just have joined as a member of National Human Rights Commission for 2.5 months, and my experience is, I am just sharing with you, it is very difficult. Reason being, we have got 27 state human rights commission across the country. In many of the places, there is no chairperson. In many of the places, there is no members. In many of the places, there is no staffs. In many of the places, there is no officers. In many of the places, we are not able to handle these things in a way it is required to be done. But what is the reason behind it? The reason has not been shown by anybody. Rather, we are lacking. Rather, I would say the person who is seeking relief is not getting the relief what he ought to get within a short time, that we are not complying. Why that is not being happening, that reasons are, we have to discuss and find out in our technical sessions. I just point out one thing, that people who are coming to the tribunal and commissions, they are in need of getting speedy justice within the constitutional mandate as provided under Article 21. But question is, then are they getting such benefits? If answer will no, then there is no need of existence of any commission or tribunals. If answer is yes, can we revamp it so that at least people can get the benefits? And which people are coming to this commission and tribunal? Speaking for National Human Rights Commission, I am saying that persons, those who don't have any money to spend running to the court process, because now it is an expensive one. He has to engage a lawyer, he has to run after the file, he has to wait to get the justice, there is a delay in disposal of matters. Therefore, what has happened, by the time he gets relief, he has already been exhausted. Therefore, to get an immediate relief, this methodology has to be carved out, and Human Rights Commission has been established to extend such benefits to the people under the law, so that anybody merely files an application, that application will be taken care of, and action taken, report has to be taken, then the adjudication process has to be continued. Therefore, if this is the shortest methodology we are adapting to do, are we reaching are granting such benefits to the person concerned who is asking for such relief? If these are the questions to be considered at the time of your technical session, and more particularly, I find that suppose a commission has been appointed during a regime of one government, and in the meantime, they have been superseded, a new government has come up of different parties. They are also not been responded. And yesterday I was discussing with some of the members. They are also expressing their helplessness because the region is saying that, sir, we have been appointed under X government, but now we are finding out difficulties to do the work because now the present government says that cases should be instituted against these commissions because why they are so much active. Therefore, if somebody is active, he will be penalized. If somebody is inactive, he is also being penalized. Then in what way the problem can be solved, that is to be decided here at this present juncture. And I hope that you are all learned persons sitting together and you will be ably assisted, and also you will also give your feedback to us so that at least the director Bihar will take a call to do the best of the best for the nation. Because I find that persons from across India are representing today. I am so happy that at least there should be exchange of views, exchange of knowledge, exchange of understanding, exchange of the thoughts, so that at least this sharing can be made amongst ourselves, and the outcome of that understanding is to be parted to the director so that he will deal with the same in proper level. Thank you for giving this opportunity to me to express my views.
Thank you, sir. Now, we would humbly invite the chief guest of this national conference, Honorable Mr. Justice Amreshwar Pratap Sahi, President, National Consumer Dispute Redressal Commission, to address this esteemed gathering.
Thank you, Bihar, for once again inviting me. Thank you, Mr. Pathak. And let me congratulate the entire state in the presence of learned Advocate General. Bihar has completed 113 years of its creation only yesterday. And the commencement of this conference shall be remembered in history, that we were invited in a conference, as Justice Rajiv Ranjan Prasad said, to enlighten ourselves. I would go one step further, to emancipate ourselves. Bodhgaya, a place for not only enlightenment, but with Bhagwan Vishnu's pad here, it is also a source of emancipation, and certainly this conference is going to yield those results which are expected, as Mr. P.K. Sahi pointed out, that we will certainly gain something. All my lords on the dais, all my lords of the dais, honorable guests, ladies and gentlemen, I would like to bring something to your notice, because Honorable Mr. Justice Rajiv Ranjan Prasad has really given me some fodder to talk about something which we are going to do in the sessions, and that is the art of innovation. We are the foundations of those consumers, of those litigants who are facing tribunals, who expect justice at grassroots level. High courts and the Supreme Court, of course, they are constitutional courts. It is their job to innovate and to apply law. And the judgment which you cited, which I had made an inquiry into, was made the basis of discussion at the National Judicial Academy. And questions were asked as to, if a convicted person is behind bars, how can he exercise any fundamental rights? Because his fundamental rights under the Constitution, once convicted, stand suspended. I had to explain it. I would not name anybody, but in the presence of Honorable Supreme Court judges, that you have to understand that Article 21 of the Constitution of India envisions to protect the right to life of all citizens, whether inside jail or outside jail. A person convicted has a right to breathe. He has also a right to think. Can you stop a man from thinking inside prison? You would have never got independence, because Gandhi and Nehru and all leaders who led us, they thought in prisons, and they gave you this wonderful nation. You never know that the person who is imprisoned, how far can he go to think, even in imprisonment? So does all his fundamental rights vanish? Does it amount evaporation of rights? Does it amount to extinction of rights? And then I have to go one step further. They are natural rights. The Supreme Court, after the right to property was deleted, defined Article 300A, and one of the judgments says that right to property, even though may have been removed from the chapter of fundamental rights, it is still a natural right. Right to procreate is a natural right. Who can and how can this right be snapped on account of any conviction? Conviction is for an offense, for the crime one has committed. And at the same time, they again put a question. What about an unmarried man? Or what about a widower who does not have a child? He can also say this. My straightaway answer was, go one step further. We are all talking about our hearts bleed for the accused. We all talk of bails, we all talk of rights. The moment we get a criminal case, we hardly think about the victim. Here the wife is a victim. Please think it from that point of view. What about her fundamental rights? What about her natural rights? And I was reminded of another decision of the Patna High Court where I had to reverse it. But the Supreme Court, even though did not reverse my judgment, upheld the single judge. Honorable Justice Jyoti Saran had delivered that judgment in the recruitment of constables. And his first sentence, I still do not forget, is motherhood a bane or a boon? And the Supreme Court approved of that philosophy, even though it did not upturn my judgment, but reversed it under Article 142. And they said, no, this is somewhat, to bear a child is natural. So your judgment was answered on discussion. And therefore I am happy you have raised this. The reason being, I want all of you who have come here, that whatever you gather from this conference, please innovate and take the law forward. All of us are here to talk about what are the difficulties, the issues and challenges. The main challenge is of innovation. We should not stagnate. We should progress. And progress by research, progress by hard work and progress by laying down the law for the benefit of those for whom we have been placed in office. So, it is this challenge which you are meeting every day. You get involved in one case or the other. Please get involved in solving that case. And the dates that we are talking of, obviously, at times these dates are because we are unable to solve it. So, solving our own problems, we talk of infrastructure also. I have seen judges writing judgments with their own hands. I also do it up till now. There is no stenographer. Even if I am not very pairy with my computer, please do it. Don't allow yourself to sleep on the ground that your infrastructure is lacking. At least if you can't write 4 judgments, you can write 1. So this is how you contribute. And not only contribute, you prove that you are competent to have been appointed the post that you are holding. So this problem is universal throughout, in all tribunals, in all commissions. Just for your information, a latest article published in newspaper Mint, dated 11th March 2025, tribunal reforms are a must for efficient resolution of disputes. And this article is by none else than by a very eminent planning commission, former economist. All of you must have heard about him, Mr. Vijay Kelkar. He writes about some dismal performance of some of the tribunals. But I am it was really heartening to read, and I just read it from the newspaper. Although tribunals like Central Administrative Tribunal, Armed Forces Tribunal, Consumer Dispute Redressal Commissions, Income Tax Appellate Tribunal have performed relatively better in resolving disputes, the fate of tribunals in India ultimately hinges on the government's willingness to prioritize judicial autonomy. These are words of wisdom. It is the government's duty, 3 organs of government: legislature, executive, judiciary. We are part of that judicial system. I have always said, whenever I attend conferences on ADRs, it begins with alternate dispute redressal mechanism. I adopt the later definitions. It is not alternate dispute redressal mechanism. It is appropriate dispute redressal mechanism. We tribunals and commissions have been found under the Constitution to be the appropriate tribunals to share the burden, judicial burden of the normal judiciary and for speedy justice. But unfortunately, with all these hurdles, the position has slightly reversed. But when I read this newspaper, I thought I should share it with you that at least there is some light at the end of the tunnel. People are there who recognize us and say that yes, we are performing better. Another thing that I wanted to point out, because a lot of infrastructural problems are being pointed out. I had been personally in contact with Mr. Venkatramani, the learned Attorney General, to push all the pending matters before the Supreme Court. And very lately, I hope you must have read in the newspaper the order that was passed on 5th of March 2025 by the Supreme Court of India in re pay and allowance of members of the UP State Consumer Dispute Redressal Commission. This order, categorically, I'll just read it for the information of all of you, that we are, whatever is possible, the judiciary itself is trying to help itself. The court has fixed 8th of April and has also issued, we direct all the state governments to ensure that without prejudice to various contentions raised in this group of cases, salary and perquisites as per existing state rules shall be immediately paid to the chairperson's members. In the event compliance is not made by some of the state governments, the concerned parties are free to hand over a note to that effect to the learned amicus curiae for appropriate orders on 8th April 2025. I believe learned Advocate General must be having some notice of this order, but if not, please ask your government. 8th of April is the date fixed. If they can help, if they can make some better promise to better our conditions, things will move forward. Now, it is not only these things, but tribunals all throughout the world, wherever they have been constituted, suffer from this sort of some malady, as was highlighted by Honorable Justice Rajiv Ranjan Prasad when he talked about the Bihar arbitration tribunal. It is correct that the first pillar on which a judiciary functions in a democracy, I'm not talking about a communist country or countries having dictators, but when it comes to a democracy, it is the independence of the judiciary which is the bulwark of the protection of all rights, whatever they are, fundamental, natural, legal, any rights. The independence of the system which is the bulwark which infuses faith in the public. And that is essential for deliverance of justice. This is what every man aspires for. It is not only our efficient functioning and infrastructure, but even if it has been delayed, it should be justice. The denial on account of delay should not end in injustice. There is no scope of injustice. So, whatever be the position, all our tribunals, howsoever they have been constituted, they have been constituted to deliver impartial justice. And impartiality can only be on the basis of independence of that institution, and this institutional infrastructure is required to be strengthened by providing that independence in the statute itself. For example, in our under our Consumer Protection Act, the protection is there that all actions, orders passed, shall be treated to be actions in good faith. But I dare say, again, without any disrespect to the higher judiciary, at times the High Court and the Supreme Court intervenes in matters on such grounds that it becomes difficult to define as to who is wrong and who is right. I will narrate just one small example, and I did not narrate it on the last occasion for some reason, but I will again narrate it today. There is a provision under the Consumer Protection Act that if you don't file your written statement within 30 days, your right to file a written statement will stand forfeited. There is a grace period of 15 days and therefore 45 days. Not beyond that. There is no discretion left. A case came up in which the lawyer himself appeared on caveat and said that I am receiving notice. Obviously 30 days will start running from then only. Date was fixed after 3-4 months. Matter was taken up. Then he says, yes, I had accepted notice, but the petitioner did not serve me a copy of the complaint, therefore my 30 days has not started running. Now, what is the purpose of a notice? The rule of audi alteram partem. If you are accepting notice, then notice is dispensed with. Copy is available with the registry. You are standing there. All right, you can ask by moving a small application that I have not been served or the registry has not given me. You don't do it and after 4 months you come and say, I have not received it. Of course, that request was rejected and the matter proceeded. It was a builder-buyer dispute. Went to the Supreme Court and the Supreme Court says, yes, this order is too harsh. We are setting it aside. There were no less than 62 complainants who were flag buyers and who were the respondents. Rather, the complainants and respondent in the Supreme Court. The Supreme Court says, we allow the appeal, set aside the order, subject to the condition that the builder shall pay to all the complainants rupees 1 lakh each by RTGS and file it before the National Commission. Now please tell us, which order was harsh and which is harsher? Because the builder paid 62 lakhs for filing a written version. Nothing to, at times you feel bewildered as to whether this system which has been made for an easy passage of justice, should it be covered with any such aura where for the next time a person entering the Supreme Court might think 5 times as to whether I will be burdened or overburdened. So judicial interventions at times are creating problem. The second area is jurisdictions. Of course, this is our duty as tribunals to understand our jurisdiction. We cannot travel beyond what is stated there. But I am tempted just to tell you, because this is for all tribunals, the Supreme Court very clearly, now it says that in L. Chandrakumar's case, all of you know, that tribunals may decide questions on constitutional validity of statutory provisions. However, they will be considered as a supplement rather than as substitute to high courts on such matters. Thus, their decisions on such matters may be examined by whom? By the High Court in a division bench. And 227 is exercised by single judges. What happens to the ratio of this decision? And what is happening is 227 filed before single judge, no special appeal lies, no letters patent lies, so it never goes before a division bench. Mandate of law. Therefore, at times we find it difficult to explain to our members as to what should be followed and how. But of course, the order of the High Court, whether single judge or division bench, that cannot be our concern, it has to be followed. The only inhibition put forward is that the tribunals must not adjudicate on questions related to the constitutionality of their parent statute. This is the limitation on tribunals. Please keep it in mind, you cannot decide the constitutionality of the statute, but the constitutional validity of statutory provisions can still be decided by you. This distinction you should have in mind, and you should not be hesitant in taking decisions to that effect, because this is a constitution bench. There are many more issues we will discuss in the plenary sessions. all the issues have been already flagged. I have pointed out to you that the matter is being taken up before the Supreme Court. Hopefully, these issues would gradually get resolved. But the problem is that which has been expressed by Mr. Vijay Kelkar in his article, the willingness to prioritize how to take the horse to the pond. A tribunal is a creature of the statute, which is a creature of the legislature with administrative control of the executive. So how does the tribunal drive to the legislature or the executive to the pond? A small experiment has been conducted by me, and I do not know whether I will be successful or not. And I will end with that because we are to join in our sessions. Yesterday in the newspaper, I forgot to bring the Times of India, a 5-member delegation of the Supreme Court has visited Manipur. And in Manipur, one of my former colleagues from Madras is now the Chief Justice, Justice Krishna Kumar. There are 3 judges over there only. The 5-member team was to consist of another Honorable Judge of the Supreme Court, Honorable Justice Koteshwar Singh, who belongs to the Methi community. And this 5-member team had to visit Chandrachudpur, which was the center of ethnic violence in Manipur and which is the hub of Kuki community. Now the lawyers there pass a resolution that we will not welcome Justice Koteshwar Singh because he belongs to the Methi community. Now look at this, where we have reached. The faith of the judiciary is being tested on the community of the people. Irrespective of the fact that Justice Koteshwar Singh became a judge in Assam High Court, he had studied throughout in Delhi, he had got nothing to do with communities. But when it came to his visit in order to resolve anything, this is the response that the Honorable Judge gets, and he had to drop his program, which has been reported in the newspaper yesterday. Full headlines to this effect: Supreme Court Judge opts out of team because of this. Now the point that I wanted to make is that what we have to innovate and what we have to do. A case came from Manipur. A person buys a Hyundai car. The person who is buying the car is a Methi. The dealer is a Kuki. The car was booked in 2019, full payment made. It was to be delivered in 4 or 5 months or whatever time had been. Unfortunately, the ethnic violence broke. The purchaser says, I will not come to take delivery of vehicle, you send it to me. And the dealer says, if I bring it to you, they will kill me, so I will not deliver it to you. Now the consumer dispute vanishes in thin air and Kuki versus Methi begins. Now that Bishnupur or something like that, whatever is that place name, district commission is there, it says, what am I to do? It keeps on fixing dates. Again the dates are being fixed. This is one of also the problems. Now here you have to innovate. I write a full-scale order. I brought it along with me. We will discuss it in the session. That you please provide infrastructural facilities, internet facilities, so that they can connect online and you decide the matter. There is no occasion for anyone to come and go. The district commission says that we have no funds. State commission has not given it. I pass another order requesting the state commission secretary and also sending a copy of the order to the central government, please send it and get it implemented. Letters are being exchanged And again, coming back to Mr. Kelkar, that willingness to prioritize is not there. Till date, only last Friday, case could not be taken up, so I had to issue a show cause. Why should it not be transferred to another state? Now, will that not be a burden on the litigants? Will that not be another burden on the system? So this willingness to prioritize, of course, that is lacking throughout the country, but tribunals are no less than courts. They have the trappings. They know what they have to do. Of course, it is a summary jurisdiction. Rules of evidence, rules of civil procedure will not strictly apply. That we will be discussing in the plenary session. But these are the inhibitions which are also impeding, and it is here that at your end, judicial reforms are required. So we should talk about what we can do. And we have to remember John F. Kennedy, don't ask what your country will give you, tell them what you can give to your country. So please tell the public at large what you can give to them, whatever limited sources are there. We all know India is a mixed economy. We have all sorts of people, one who are well fed, one who are underfed. But both of them try to get 2 square meals a day in spite of all odds. And that is what is known as emancipation. So thank you very much. With this conference, please emancipate yourself. Try to learn something and give something. Serve. We are there to help you, whatever we can do. And we will leave no stone unturned to receive such accolades as has been given by Mr. Kelkar to us, in spite of all the odds and hurdles. So with this encouraging note, welcome to the conference, and I wish this conference another grand success. We will discuss all legislative inhibitions, executive inhibitions, as well as our own shortcomings, and we will try to deliver the best. Thank you very much.
Thank you, sir. Finally, we would humbly request Additional Chief Secretary, General Administration Department, Government of Bihar, Dr. B. Rajender, sir, to propose the vote of thanks.
The Chief Justice of the conference, Honorable Mr. Justice Amreshwar Pratap Shahi, the President of NCD, RC New Delhi, Sri P.K. Shahi, Learned Advocate General Bihar, Honorable Mr. Justice Rajiv Ranjan Prasad, Honorable Judge of Patna High Court, Honorable Mr. Justice Anand Sen, Judge of Honorable High Court, Jharkhand, Honorable Dr. Justice Bidut Ranjan Sarangi, Member NHRC New Delhi, Sri K.K. Patak, Director General, BIPAT, esteemed panelists, distinguished guests, legal experts, ladies and gentlemen. So it's my privilege and honor to extend a heartfelt vote of thanks at the conclusion of this inspiring and insightful inaugural session of the one-day national conference on the issues and challenges faced by the state commissions and tribunals. This morning, we have been enlightened by the thought-provoking addresses, setting tone for an impactful day of deliberations, and I extend my deep sense of gratitude to our chief guest, Honorable Mr. Justice Amreshwar Pratap Shahi, for his profound insights and evolving role of tribunals and commissions in delivering justice. Sir, the prioritization, willingness to prioritize issues is very important, sir, and your practical issues which you have highlighted will definitely come a long way in reforming the tribunals and commissions, sir. I express my gratitude to Sri P.K. Shahi, Learned Advocate General, for enriching the perspectives on legal challenges faced by these institutions. You mentioned about the appointments and issues and vacancies, sir. Definitely, it will this conference will solve all these issues. I would like to express my gratitude to Mr. Justice, Honorable Mr. Justice Rajiv Ranjan Prasad, Honorable Mr. Justice Anand Sen, and Honorable Dr. Justice Vidyut Ranjan Sarangi for their invaluable wisdom in highlighting the significance of legal reforms and administrative efficiency in these forums. Honorable Justice Rajiv Ranjan Prasad has mentioned about date, Tariq pe Tariq. I think it will really, as our Chief Guest mentioned, we have to innovate how to resolve this issue. I would also like to thank Sri K.K. Pathak, the Director General, BIPAT, for organizing this conference, which has set the foundation for a meaningful and constructive dialogue. Your words have not only inspired us, but also provided a strong intellectual framework for the discussion that will follow throughout the day. A conference of this magnitude is made successful by the enthusiasm and the commitment of all those participated in this conference. I would like to thank all our esteemed delegates for joining this vital conversation and bringing diverse perspectives and expertise to the table. I would like to thank the organizing team of BIPAT for their tireless efforts in ensuring seamless execution, all our distinguished guests and attendees whose presence reinforces the significance of this dialogue. Your collective efforts are what makes the platform a true confluence of knowledge and change-making ideas. While we have begun with deep reflections on the challenges ahead, I remain hopeful that this conference will lead to a pragmatic solutions, policy recommendations, and a renewed commitment to making our justice system more accessible, efficient, and people-centric. As we move forward into the technical sessions and the plenary discussions, I am confident that the ideas exchanged today will influence policies, improve legal frameworks, and ultimately benefit society at large. I once again thank all our esteemed guests, speakers, and the participants for being part of this vital initiative. May this conference be a milestone in strengthening the role of tribunals and commissions in our justice system. Thank you all. I look forward to a day filled with impactful deliberations. Thank you very much.
Thank you, sir. We would extend our heartfelt gratitude to all the esteemed dignitaries present at the dais for this productive inaugural session. Now, we will take a short coffee break. But before that, I humbly request all of you to kindly assemble in the central lobby for group photography. Thereafter, we will reconvene at 12:30 p.m. for our technical sessions. The technical sessions will be held in 3 halls. First technical session on land reforms and right to information will be held in this hall itself. Technical session on consumer disputes will be held in Committee Hall 1, and technical session on human rights and child rights will be in Committee Hall 2. Thank you.
One more small announcement. The arrangement of tea and coffee for the delegates is on the ground floor, and for participants it is on the first floor. Thank you.